I'm going to give you some rules to help you prepare to give a deposition. Now, these rules are primarily for the witness who has never given a deposition before, or for the client who is about to testify for the first time in their own case. However, many of these rules apply just as well to experienced witnesses, because it always helps to be reminded of some of the basics. So rule number 1, tell the truth. You are under oath. It is the exact same oath that the court reporter is going to give to you in a real trial in a real courtroom. And the same rules apply. So I tell all my clients, rule number 1, tell the truth. Rule number 2, listen carefully to the question being asked and make sure you understand it before you try to answer it. Lawyers are sometimes pretty good at asking confusing questions. Sometimes this happens on purpose, sometimes it's merely accidental, but the point remains that don't ever try to answer a question unless you're sure what the question is asking. So I tell my clients, if you're not sure or you seem a bit confused, ask the lawyer who's interrogating you to repeat the question or to rephrase the question or to explain what he means by a word that he uses. Sometimes lawyers use big, long words when they don't really have to. So it's important that you understand what the question is. There is no limit to the number of times you can ask for a question to be repeated or rephrased. Rule number 3, don't guess or speculate. If you don't know the answer to a question, don't try to come up with an answer that you think might be the right one. Instead, it is far safer to say that I don't recall, or I don't know at this time, or I would have to check my records before I can answer that question. The worst thing that you can do is to guess and have it turn out that your guess was wrong, because that can typically get used against you later, where a clever lawyer could try to make it look like that you were lying, and you certainly don't want that to happen, because in any case, credibility or believability is probably the most important thing for a witness to have. So if you're not sure of an answer, don't guess. And rule number 4, don't volunteer extra information. Only answer the question that is being asked. And so this comes back to haunt many witnesses in depositions. So for example, a witness may be asked a yes or no question, but they proceed to give a 3-minute answer. And that 3-minute answer has so much extra information in it that it leads the lawyer asking the question to follow up on another 10 or 12 questions. So be short, be concise, and get to the point. There are some exceptions to this rule of don't volunteer extra information, and your lawyer will cover those with you prior to your deposition. One example of an exception is, if yours is an injury case and you are the injury victim, you may be asked a question of, tell me the ways in which your injury has affected your life. Well, that is usually a cue to give a longer answer explaining the many ways that the injury has changed your life for the worse or affected your day-to-day living. But if you're unsure how to answer any particular question, it's important to fall back on the 4 rules that I've given, which in summary are, number 1, tell the truth. Number 2, make sure you understand the question before you answer it. If you don't, have them rephrase it. Number 3, don't guess or speculate. And number 4, don't volunteer extra information. Try to have a short answer that covers only the question asked. Another important thing to be prepared for in your deposition is if there's going to be documents that are used and you're going to be shown the documents and expected to answer questions about them, then it's important to know what those documents say. In most cases, the lawyers can anticipate what some of those documents will be. For example, in a car wreck case, there is usually an investigating officer's police report. It's important, if you are giving testimony in a car wreck case and you were involved as a driver, that you understand what is on that police report, because you will probably be asked questions about it. If you are shown a document, such as a police report, and they start to ask you questions about it, take the time to read it. So a lawyer may say, "Do you agree with the officer's opinion on page 2 of the report?" Well, before you say yes or no to that question, make sure that the lawyer points out exactly what they're asking you if you agree with. Another example that comes up in injury cases having to do with documents. An injury victim has usually sought medical care. There can be voluminous medical records from a lot of different sources. Frequently, a lawyer for the other side will ask that injury victim specific questions about the medical care that they've received, and sometimes questions about what they told the doctor or what the doctor told them. So I advise all my clients to be familiar with their medical records. Certainly you don't have to memorize them, but you need to know the basics of your medical records. So we'll usually create some kind of chronology or summary of those records and review them with the client. And if the client is asked a specific question about a particular doctor visit, and it's clear that the lawyer asking the question has the record in front of them, it's usually wise for that client to ask, may they review the document they're being questioned on. So I never really want my clients to answer questions about documents unless the client has also had the opportunity to see the document before having to answer questions about it. Another example of documents that can be used in a case and that a lawyer may ask a witness about in a deposition would be letters or emails or things like that. So in a case involving a contract that was breached, there will be contract documents. There will usually be an exchange of information long before the lawsuit started. And so anytime we anticipate that documents are going to be used in a witness's deposition, then it's important for that witness to have a good familiarity with those documents. One other thing to remember is that you are allowed to take breaks during your deposition. It is not a marathon. So if you need to take a break and speak with your lawyer or go to the restroom or for whatever reason, simply ask and permission will usually be granted for you to take that break. Often clients will want to know how should they dress for their deposition. In this day and age, it is common for depositions to also be recorded by video in addition to a court reporter taking down every word that is said. In that case, we ask our clients to dress like they would for the office. If they don't work in an office, then we ask them to wear a nice shirt. If they're not the kind of person that wears a suit and tie every day, then we do not expect them to wear a suit and tie in a deposition. But if they are a business person that is usually wearing a tie and coat, then that's appropriate for the deposition. So nice casual clothes, church clothes, but something that's presentable. And when all else fails, just a button-down blue shirt is standard deposition attire.